Hi, everybody. This is Paul Hitchcock with BarthCalderon. Welcome to Wealth Protector TV. You might be listening on Wealth Protector Radio here, and I'm really excited to have the founder of our firm, Harry Barth, on. And we're getting some education out to those who are connected to our firm on some very hot topics. And Harry, I just want to jump right into it because you were talking offline about what's going on in the current business and legal climate and maybe some tools and strategies to talk about.
Sure, absolutely. Well, thanks, Paul. It's good to be here again on Wealth Protected TV and or radio. It's interesting. I get asked questions all the time about, what is asset protection? And let's start with the broader and then do a little narrow. Then we'll talk a little bit about the times that we're currently in. And we'll take one subject matter that's really been evolving, a hot topic over the last 20 years, and talk about that as well. Well, first of all, asset protection planning, really, there's a misnomer that it's only for the super wealthy. It's for everybody. It's just organizing our affairs, our insurance in such a way that we are in the best position to withstand a legal assault on us and end lawsuits early, or in some cases, even prevent lawsuits. I was in a meeting early this morning that was involved with a $100 million lawsuit, which was
Jeez.
finally settled after 8 years. And the attorney that led the settlement, very, very prominent litigator here in Orange County, said that the only reason it was able to settle was because of the pivotal impact of the asset protection strategies that were adopted by the client before the lawsuit began. He says absolutely pivotal, and the client would not have survived if he did not.
Well, Harry,
So
is that because the asset protection, when they see it, they know it's an uphill battle, and I
I
mean,
think it was part of an uphill battle. It made the battle more difficult, and after numbers of years, enabled people to reach a more common point of interest and be able to settle the case.
okay.
Pivotal. So it was funny. When I think about that, people do tax planning. Tax planning is done all the time, and when we're doing tax planning, what are we doing? It's asset protection, isn't it? It's organizing our income and our affairs in such a way that we keep the maximum amount of income and assets and minimize the take that the various state, local, or federal governments take. It's protecting our assets. When we
Right.
do estate planning, all right, we are protecting assets from the grips of the government for state taxes, state death taxes, creditors, probate claims, courts, lawyers, to have a smooth and private transition. That is also protecting our assets. One is protecting our income, another one, and assets, another one is protecting our assets at the time of our death. And when you think about it, as you know, I'm a 40-year financial planner as well. And when you think about it, what is financial planning? It's organizing our affairs in such a way to have proper diversification in investments, to have our retirement plans appropriately protected. So when we do financial planning and planning for the future, we're also protecting our assets from debt, excessive interest rates, and everything else. So asset protection is quite significant. Now we're at a time, man. I've been in practice a long time, and I have never seen anything like 2020. 2020, we were all experiencing novel things, the novel virus of COVID-19 and its impact on the legal world, a tremendous amount of political uncertainty, and an election that brings a sharp contrast between the direction and taxation in the United States of America. COVID-19, our first worldwide pandemic in 100 years, has had tremendous economic impact. And what I also believe, and I think it's beginning to work its way out, is that COVID-19 will also result in a significant amount of potential new liability. As if we didn't have enough liability in the
Yeah.
workplace, or enough liability, just by being a citizen in the United States of America, driving a car, owning a home, we now have the impact of the uncertainties in contracts. What if
Are you already starting to see some of that come around?
I am contracts being unable to be fulfilled? And the claim is that it's because of the virus that they couldn't fulfill the contract. and people saying, no, you could have fulfilled the contract. It opens up, this force majeure, business interruption. We're also being highly concerned, and we're beginning to see lawsuits show up about making sure that the workplaces are safe for employees. If an employee contracts COVID in the workplace, brings that COVID-19 back to home where grandma lives, grandma contracts COVID-19 and sadly passes away as a result of the virus. We're anticipating we may see a wrongful death claim against the employer for failure to provide a safe workplace for the employee, i.e., and now grandma is gone. So, and then we have people that just can't fulfill contracts. We have scenarios where people have done price gouging during COVID-19. We have many issues that I think are yet to come. And we also have this area of political uncertainty. So I think at this time, it's always a good time, but at this time especially, it'd be great for everybody to kind of sit down and take inventory. It doesn't have to be a big deal. It doesn't have to be a highly expensive deal, but to take a look at what assets we own, how they're held, what their vulnerabilities are, how they should be insured, what legal structure should be in place to protect them, I think is very, very, very important. And the sooner you do it, the better. The asset protection is so much stronger when it's done preemptively and proactively. It's still helpful providing speed bumps when someone's hair is on fire, but not as effective.
Harry, you mentioned the domestic asset protection trust as a tool that is fairly common, I guess, that you use.
Well, I don't know if the term fairly common is correct, but let's just turn around and talk about one tool today from as an evolving area of the law. So the question, many years ago, it's always been the fact that if you establish the trust for yourself and you place your assets in the trust, to the extent that that trust benefits you, a creditor can reach the assets of that trust. That's been established as part of the United States common law for so many years. About 20 some odd years ago, that was turned upside down when the state of Alaska announced the allowing of the first domestic asset protection trust. What is an asset protection trust? In its simplest form, it's the creation of a trust for Paul, by Paul, for the benefit of Paul and Paul's family, that Paul can contribute assets to, that can be used for the benefit of your family, but a creditor cannot reach those assets.
Mm-hmm.
Now, in order to do that, and in the history behind that, probably beyond the scope of the time that we have today on Wealth Protector TV. So the importance of that is that if for a state to provide that level of protection, there had to be certain rules. And certain rules, which I think seem to make common sense. Common sense rule number one is that you don't establish an asset protection trust after the events that gave rise to the liability have occurred. So to make it in the simplest term, if we have a serious automobile accident on Monday night and a lot of people were injured, it's not a great time to establish a asset protection trust on Tuesday morning, although we'd all want to at that point in time. It's better to proactively build the castle and put our assets behind the castle walls before that occurs. So pretty much in all jurisdictions, and what started as one jurisdiction in Alaska is now about 19 jurisdictions, I think with the last jurisdiction, Connecticut, approving domestic asset protection trust legislation. So the trend, and this is very important, is moving forward. More states are adopting asset protection. I think eventually, potentially, all states over the next 10 to 15 years may establish domestic asset protection trust legislation.
So it's not your living trust, and it's not about losing control when you set this up.
No, it's not. It's not a living trust whatsoever. It's a completely different trust. There are aspects of control that you have complete control over, and some aspects where we've limited the control somewhat. Because we need to make sure that the trust will provide the necessary protections needed in the event that we have a claimant. Now, there are a lot of nuances to this. There's jurisdictions, there are court jurisdictions, there are cases, there are lots. It's an emerging area of the law, but it's emerging really quite favorably. And so besides that, we don't want to do it after the fact. We want to make sure that when we set up a domestic asset protection trust, that we're not doing it to harm spouses and spousal support, children and child support in those areas to make sure that's done. And we want to make sure that all of the assets that are funded into an asset protection trust come from legal sources. So we want to make sure everything is legal and everything is good. So once we have an established trust and the trust is funded, the opportunities for protection are boundless. Now, one of the concerns that we have is that as it's an emerging area of the law, the actual, whether it's definitive or not, is evolving. So for example, if one established a domestic asset protection trust in the state of Nevada, and one is a Nevada resident, and one or Nevada business, and the liability rose up in Nevada, it's pretty clear that that asset protection trust, if established properly and not after the fact, will protect those assets for family. What's less clear is what happens when we have a domestic asset protection trust that was established in Nevada and the resident is in California, which does not have domestic asset protection trust legislation at all. So, so that area is still emerging and evolving. Some of the more recent cases have indicated that many courts, if established properly, are respecting the boundaries of a domestic asset protection trust, and if done properly, may provide a pretty good barrier and guard around various different types of assets, not creating an insolvency, but different types of assets that could be protected for family. You know, and let me give you an example of that in reverse, in that many years ago, as we all know, the Supreme Court adopted some court cases which protects our retirement plans. So our defined benefit plans, our profit sharing plans, our 401k plans, ERISA protected, are not subject to the claims of creditors. So that's how O.J. Simpson was able to keep, I think, $25 million of his NFL and business pension plans, even though there was a wrongful death claim against him by the Brown and Goldman families. So the barriers that are built around retirement assets are pretty strong in the United States of America. But if somebody like you or I were building our retirement through the use of businesses and real estate and investments, and not necessarily in an ERISA qualified retirement plan, we did not have the same level of protection. We should have the same level of protection. It's just not fair.
It's not a level playing field. Yeah.
We should have the same protections. And I think that's some of the motivation in creating things when done properly and not abusively. But more than anything else, I think there's also an understanding of the trust being created in a default. There's no doubt, Paul, if you had $1 million worth of stocks, bonds, and cash, and it's in the name of Paul Hitchcock, and I have a judgment against Paul Hitchcock, that I can go in with my judgment, levy that bank account or those brokerage accounts, and clean out those assets. So there is no fence, there is no barrier. But if those funds are held in a properly prescribed limited liability company, which is held by Paul Hitchcock's Domestic Asset Protection Trust, we have many more things that have to happen as to whether or not the creditor can reach those assets, you know, even if you're a California resident having established a Nevada trust. I think that playing field or the analysis or the litigation around that is full, fair, and proper to determine whether or not those assets should be protected or not. It's for sure, if we don't have it, we're not protected. If we do have it, we may be protected, and the law just seems to be getting better. So I think that, I think in many cases, this is an area for exploration that many of our clients, our associates, our colleagues should become more familiar with, and helpfully help establish those barriers on behalf of their clients. There are many, many, many tools in asset protection. That's just one of them. And we hope over the next number of weeks, Paul, through Wealth Protector TV, to bring more tools to everybody that we can explore. Remember, these are always 36,000-foot views. There are always caveats and conditions and covenants with anything that we do, and should be done by an appropriate and properly licensed professional.
Harry, as always, you're a fountain of knowledge on these topics. Really appreciate it. And I want to thank everybody for listening here. And as soon as your schedule frees up, Harry, I'm going to try to get you back on here.
We look forward to it. Thank you so much, Paul. Everybody stay safe.
All right.
Bye.
Thanks.